Of your time. Okay, we'll do that. We have a couple of people signed up to speak for this, and if you don't mind, I'll ask Senator Robinson to offer a brief prayer.
Thank you, Mr. Chairman. Those who are comfortable, if you bow your head with me. Good afternoon, our Father in heaven. We thank you, Lord God, for the blessings you've given us today. We thank you for the beautiful day you've given us, provided for us, Lord God. And God, please remind us of the responsibility we have, Lord. Continue to remind us as we move through this legislation, the impact that it has, Lord God, not only on the individuals involved, but the citizens throughout this state. And remind us always, Lord God, to keep our minds open and our hearts. We ask these things in the name of your Son, our Savior, our Lord Jesus Christ. Amen.
Amen. Thank you, Senator Robinson. As I said earlier, we're going to have a hearing today and try to get to the areas we want to get to and deal with a study committee as well. We might just move that one out so we can get that going. I'm very, very interested in this Senate study committee because I think it's something that we really need so we can just sort of streamline this thing and take a lot of, I think, unnecessary input into it after it's been adjudicated and filtered through a lot of committees and things like that. That way we can deal with it. So what I will do, I'll go by the hearing first, and then I go down the list. We got 4 bills, and we got 1 study committee, and I'll start with the hearing with input from, is this Clarence Harris? Harris. Would you come up, sir, and sit right there? We'd like to hear your comments. Are you speaking on any one of the bills we have here today or generally?
Compensation bill for safeguard that's needed for the authorities and the procedure.
All right, go ahead.
Yes, I'm Clarence Harris.
Generic.
And I'm George Johnson Project First Exoneree. I was exonerated in 2004. And I served almost 18 years in prison for a crime in which I did not commit. In 2005, I was awarded, I was supposed to be awarded $1 million, in which was, at that time, they didn't know how to, how the procedure gonna go forward with the annuities and things, which they awarded me $1 million for a period of 20 years, and they awarded to me $47,000 a year for 20 years, in which me just coming out of prison, having no knowledge how to finance that funds like that, it was very difficult, kept me in a lot of debt. I was never able to get my life together. And then on top of that, they turned right back around and I was taxed, where I had to sell the annuity to pay the taxes off, from the annuity which they gave me. I'm the only exoneree in Georgia who was taxed. And after that happened, I got hit by a car and was left for dead on the side of the road during the snowstorm. And I ended up having to pay for my own medical bill because I had no insurance. So the little money that they gave me was gone in before I even realized. But when we came up from the annuity thing, we tried to talk about the main thing that was important, that will benefit to was medical, to have tax to be exempt from taxes, and to have Social Security benefits to be established for exonerees. These was the main thing that we were arguing when they knew it came up. When they asked what did I feel like that the state will owe to me, I said, well, I can't tell you I wouldn't put a price on my life because I couldn't do that, because of what I went through. I said, but what I will ask you all to do is to be fair. That's the only thing that I asked them to do, is be fair. But wasn't nothing about the conversation was fair because there was no safeguard behind me. You give me money, then you take it back by taxes and everything, and then you make it where I can't even live off it from 1 year to the next is already gone, And, I hadn't enjoyed my life since I've been out, And I'm not only speaking about myself, but see, there was 5 other exonerees who got out from the time that I got out, who ended up getting certain stipulations on, like have to go through drug tests and all this like they still locked up. Then you got mental health people like Robert Clark, who's out there homeless and thing, Pete Williams and thing, John White, all these others in Georgia stuff don't have no kind of benefits now. You see, had they grant them annuity like they should have, give us the amount of money that they told. If you want to give it to me annuity, why wasn't it a lifetime annuity? But if you give me $1 million, I'm entitled to the interest on it. Because you only gave me $47,000, which is 5% interest. That's the interest itself.
Okay.
So I never touched the money that you gave me.
Okay, Mr. Harrison, what I'm going to do, and I didn't realize, I thought you were going to talk directly about one of these bills. What you're saying is very important, so what I'm going to have to do is ask you to sort of sit over to the side, and I'll get back to you in a minute, but I have some bills I got to take care of first.
Okay, well, I thought I was talking about the safeguard around the bills.
You are. I think you're talking about the structure of
Yes, I am, yes.
It's been adjudicated, so it's very important, trust me,
Okay.
and we'll listen to you, but what I want to do is go in the order of my
Okay, thank
agenda right here, if you don't mind, sir.
Okay.
Thank you very much.
Yes.
Okay, if you stick around, I'll have you
I
come
will.
back in a
I'll
second.
be here.
Yes,
Thank
sir. Representative Houston, if you come forward, House Resolution number 70.
Yes, and I have with me Tiffany Bracewell from Trapman, Pepper, and Sanders, too.
Okay.
Do you want
Have
me
a
to-
seat right there.
Okay,
Both of you, yes, ma'am.
thank you.
Thank you.
One of the reasons I'm here is this, Mr. Inman was from my district, and this crime was committed in my district, and I have been encouraged by constituents to bring this resolution to you because so many people at home really feel terrible about the way the man was treated and realize that he served 23 years of a crime he didn't commit. And this bill has been gone through the Claims Advisory Board, and I'm sure you saw that and they approved the payment of this and recognized that he had been done wrong. And like I told the committee when in the floor of the House, there's no amount of money that can compensate somebody that went through what he went through. And I'm sure I guess you've read this, and then Ms. Bracewell will give you a few highlights of it. But it's just a travesty that we had people in our judicial system that did some of the things to him that they did. And I think she'll just give you some highlights of the case, and I'll be glad to answer any questions.
Yes, ma'am. Yes, ma'am. Go ahead. Yes.
Good afternoon. Thank you all.
Would you identify yourself again for me?
Sure. Tiffany Bracewell. I'm a partner at Troutman, Pepper, Hamilton, Sanders, just down the street. The firm and I have had the honor and pleasure of representing Mr. Inman formally since early 2016. Thank you again for the opportunity to be briefly heard here. Invoking a 2019 opinion that Justice Namias issued in Mr. Inman's case. We're here today because everyone involved in our criminal justice system should dread the conviction and incarceration of innocent people. And that includes this esteemed body and the Claims Advisory Board and other folks who have taken a look at Mr. Inman's case. I submit that Mr. Inman's case is extraordinary. It's unique. It is momentous in its tragedy, not only for Mr. Inman, but for the Adel community. There were victims of other crimes carried out by the man that committed the offense for which Mr. Inman ultimately was convicted. And I believe the draft resolution before you outlines that well, but as quickly as I can cover 23 years of injustice, I'll give you some quick facts, some evidence, and then what the key courts in this state have said about Mr. Inman's case. In brief, Mr. Inman had just celebrated his 20th birthday when he was hastily arrested for the murder of Miss Donna Brown. She was the night manager at the Taco Bell in Adel. He was the new kid on the block. He had been in Adel for a matter of weeks when he was arrested. The investigation and the trial were infected with constitutional deficiencies and misconduct on a scale that, in my opinion, is pretty difficult to comprehend even today. Kind of most importantly, Mr. Inman's trial counsel pushed the district attorney and the GBI and the Adel Police Department to investigate a man named Hercules Brown, who had an alarming history of unprovoked attacks, violent attacks in Adel around this time. Of note, Hercules Brown worked with the victim at Taco Bell. He was one of the regular closers at the restaurant. He knew how the night shift worked. He knew the closing procedures. He knew who would be there at the end of the day. Mr. Inman's counsel and the district attorney's office received evidence to that effect. The DA's office and the GBI, for whatever reason, maybe chose not to believe it or chose not to pursue it. At least one witness had reported that Hercules Brown had solicited her and maybe other Taco Bell employees to help carry out an inside robbery. And at least 3 witnesses reported that Hercules Brown had confessed. For whatever reason, that was not enough. And to make matters worse, the GBI was permitted to testify that it had no information about Hercules' involvement in this offense, and that was belied by information in their own files. There were no eyewitnesses in this case. No one came forward that saw the crime occur. There was no forensic evidence that connected Mr. Inman to this crime. His fingerprints were not a match to those found at the scene or in the victim's car. Law enforcement never located a gun. There was forensic evidence that someone else committed this crime. And years later, well after Mr. Inman's conviction with advanced methods, DNA from the inside of a homemade ski mask found in the victim's stolen car came back to one person only, 1 in 18 quadrillion, to Hercules Brown. There's no room or interpretation for error that Hercules Brown wore that mask, and he had good reason to because he knew the victim. Unfortunately, before the trial, compounding these issues, the prosecutor failed to disclose that Hercules Brown had been arrested with another homemade mask just down the street from the Taco Bell while also in possession of a gun and crack cocaine.
Yeah, if I may ask just one.
Sure.
Can you explain to me the atmosphere that would require somebody to reveal something? Is that ordinary procedure in a law setting?
Yes,
in a courtroom
yes.
setting, I should say.
Of course.
Okay.
Under the Constitution, the prosecution
Like
team or the
discovery or
state
something, is that mine? Okay.
yes, is required to turn over information that is favorable to the defendant.
And let's, if we can, keep it as brief as you can. I don't mean, I know it's
Sure.
very, very important. What I'm getting at, can you address also, what about the process that we had involved in right here? I think you mentioned something about it. Can you give us some insight on that, what your perspective is?
Absolutely. So echoing Representative Houston's remarks, I think, in February, the Claims Advisory Board kind of made its own extraordinary statement in this case. They recognized the evidence of innocence in Mr. Inman's case, and they unanimously approved the claim for payment. My understanding is that has never happened before in the case of an exoneree. They did so without qualification and deferred to the General Assembly to compensate Mr. Inman. I'm sure some of the folks here in the audience have more experience with exonerees over the years, comparatively. But this, it's been a multi-step process. We started with the Claims Advisory Board. We've worked through various hearings, and here we are. Mr. Inman believes, and consistent with other exonerees, has sought a standard amount of compensation per year for which he was wrongfully imprisoned. That total is $1.61 million for the 23 years he spent in prison related to this case.
Okay. Members of the committee, comments, questions? Senator Robinson and then Senator Robinson.
Thank you, Mr. Chairman. Ma'am, the night of the murder, were there witnesses near the crime that reported seeing the vehicle flee the scene?
Yeah, so the state had essentially all the witnesses in the case except for one recanted their testimony either before or at trial, not decades later, as we commonly see in these cases, with the exception of one witness, a state's witness who testified she came forward a month after the crime occurred, after an award had been announced, which she ultimately received. She reported seeing a vehicle speed away from the scene, so did not see the murder occur or the weapon or anything like that.
So the short answer is yes. There were some people who claimed to have seen
Yes,
the individuals.
and-
2 individuals standing on the corner, I believe.
Yes.
And it was late at night.
It was 2 in the morning, yes,
Right.
sir.
And the vehicle they were fleeing in, was that the victim's vehicle?
It was the victim's vehicle.
Okay. And the victim's vehicle, is that where the ski mask was recovered from much later?
It was, the Adel Police Department failed to collect it, and it was recovered
Right, I think
within
we're
days.
saying the same thing. I mean, I'm not trying to trap you, I promise.
No, I
But
understand.
it was much later, the ski mask was recovered from that vehicle.
Yes.
And that's the ski mask that was tested, and the DNA came back to the individual, Hercules Brown.
Not related to the
Right, who
victim.
later assaulted the individuals at the convenience store or the general store.
Yes.
In a brutal
Double
murder,
murder,
daytime
yes.
murder. Right, okay. Now, Mr. Inman, when he was released, how was he released from prison? I'm thinking, and I'm trying to go back to my notes, a habeas was granted by the judge in the Superior Court?
That's correct.
Okay, and so the habeas sent it back to the prosecutor, correct?
Yes.
And what was the basis of the court sending it back to the prosecutor?
That's the procedure, because the prosecutor has to decide on whether to move forward with a new trial or not.
Right, because of the DNA?
No, it was on the totality of the evidence, including the withheld evidence from the prosecutor.
Right, so it would have been the prosecutor's decision. Was this the same district attorney when it was sent back?
No, it was not.
That was
Okay.
my nephew when it was sent back.
Okay, and he chose not to prosecute the case, correct?
That's correct.
Okay, and was the prior prosecutor, was that individual charged with any prosecutorial misconduct?
No, that, we're three steps removed if you include the current district attorney.
Yes, ma'am. And so that prosecutor just lost in an election, I guess, and moved on?
No, he was appointed to a judgeship.
Okay, thank you, ma'am.
Sure.
Any more comments? I'm
Wait-
sorry. Go
Wait,
ahead.
now, the first district attorney ended up going to prison. The district attorney that withheld evidence ended up going to prison, but not for this trial, not because of this. But in another instance, he ended up serving time. Later on, my nephew was the DA, who is now sentenced as a Superior Court judge.
So it was your nephew that chose not to prosecute the case?
The second time around.
No,
Okay, thank you.
no, Mr. Studstill, District Attorney Studstill.
Oh.
Yeah.
Oh, okay. Well, what about the first time around? I can't remember.
I'm not sure what you mean by the
Okay.
first time,
All
but
right. Listen, this is just a travesty.
long
And one
history.
thing that bothered me so much is that they withheld evidence and then the GBI agent lied.
Well, and I'm not going to step into that. I got some information on that, and I've been told that information is incorrect about
Well-
somebody lying, because perjury is a crime in Georgia.
Well, you might not know more about it, but from what I've understood from people down there, this man was not guilty. And I don't know what
Well,
the.
I don't
just have
think you
to-
would have brought this if you thought he was guilty.
I don't think
so
he would. And I
appreciate
don't
that.
know where, only information I've got is talking to the DA.
Yes, ma'am. Thank you.
Thank you.
Comments by the members of the committee? All right, we thank you for the input, and we, like I said, this is a hearing only today, but we will take action and look at it next week. One of the bills, all of the bills will be up for a vote or consideration at that time, okay?
Okay.
thank you all very
Thank
much.
I want to say, when you're having the study committee, we need to do something to these people who do things wrong, like withholding evidence. They need to be punished some way.
All right.
We have a prosecutorial
Misconduct.
a prosecutorial misconduct bill in the House right now in Judy non-civil, and if you'll reach out to the committee and tell them to pass Senator Robertson's legislation, we'll do something about
Well,
it. Thank you.
Thank you.
Yes,
thank
ma'am.
you. That must be
Thank
the
you very
best
much
bill
for your
we've got
time.
coming.
It is.
Thank you for your time.
Okay, and it's in Judy, okay.
Yes, ma'am.
Thank you,
Non-civil.
appreciate it. At this time, Representative, House Resolution 55, Representative Buckner.
Thank you, Mr. Chairman. I also have a couple of people that are here if they,
I did that wrong.
If-
Come on up, I'm sorry. I'll get back on schedule in a minute, I'm sorry.
do you need to,
No, go ahead and sit down.
this is Claire Gilbert and Chief Deckmar. Chief Deckmar is a police chief that is from LaGrange, Georgia, where this happened back in the 80s. What I'd like to do is just kind of give you an overview. I was drawn into a new district, as many of us were drawn, and I was invited to come into the LaGrange, Troup County area. And when I got there, I learned about this. and was asked to carry this compensation resolution on behalf of Mr. Terry Talley of LaGrange, who was falsely accused, wrongfully convicted of sexual assault. He served almost 26 years until he was exonerated and released from prison, and although he had always maintained his innocence. His exoneration came following a reinvestigation by the police, district attorney, and the judicial circuit there. In this reinvestigation, they learned that there was unreliable witnesses and testimony, biological and physical evidence had been lost or destroyed before, after, and after the trial. And there was withholding of information. But the most important thing is that the DNA evidence that was used did not match the DNA of Mr. Terry. Following the re-investigating of the cases and the DNA that had proved that Mr. Talley was not the person that did these sexual assaults, he was exonerated for the 25 years, 9.7 months that he had served. We're here today because the legal system has demonstrated his innocence. It's extraordinarily difficult to be exonerated, and he was exonerated. He was released from prison, and he currently works for the City of LaGrange in the Animal Services Unit. I'm not certain what else you'd like to know at this point, but I'll be glad to answer
Just your input
questions.
and your opinion about, especially about the process we're going through here, and give us an idea of what your thinking is about once you are, the steps of being exonerated and coming before this subcommittee or the Appropriations Committee and all of the steps you go through in that context. A brief synopsis of what you think about it.
Well, I'm very much in favor of the bill that I hope you'll hear in a little while, that is HB 364. I have worked with fellow delegation members on that bill several times. We've introduced it. I feel very strongly that this is a process that we should go through and with as little politics as possible, and have people that know about evidence, evidentiary, I have trouble with that word, processes, and that it needs to be in a commission. But since we don't have that commission, this gentleman is in his own words, a simple-minded man that has a limited education. He has served time for something he continually said he was not guilty of. It was proved that he was not guilty of it. He was exonerated. He's been released. And I think the state did him an injustice by incarcerating him those 25-plus years.
Are you aware of a House Bill 364? This is a bill that we're looking at, the wrongful conviction compensation review panel. We're trying to get a study.
That's the one I mentioned that I'm in favor of.
That's what, okay. We really, I think that streamlined the process. We need to get as many legal people that tell us, give us input on it, and whether we move forward with it or not, input. Any members of the committee? Yes,
Mr. Yeah.
Senator Robinson.
I want to thank my delegation member for coming forward, and my instructor from the Command College, Chief Lou Deckmar, whose hair was a lot darker when he was my instructor.
So was yours.
So was mine. Yeah, I do want to thank y'all for coming forward, and to talk about briefly the legislation that you were discussing on 364. I also have a bill over in Legislative Council that I agree with you 100%. I think that we need to come up with a product that does take this out of the hands of the General Assembly. Now, to Mr. Talley's case, you mentioned several times that he'd been exonerated. I just want to be clear, and of course, Chief, I know you're very familiar with the case. The DNA cleared Mr. Talley of one of the cases that he was sentenced to prison for. Is that correct? That, and I'll call that, and Chief, I know you know from your intimate involvement in this process, he was exonerated from case number 969, I believe, but he also had convictions in case number 972, 973, 974, and I believe case 970. And speaking to the district attorney there in that circuit, Mr. Cransford, there was some concerns saying that though that he was exonerated for DNA, based on the DNA from that one particular case, that was not the case in the other cases, and the district attorney still strongly feels that Mr. Talley was guilty of involvement in those other cases. And I know at one point there was testimony that the DNA could possibly belong to another individual, and a search warrant was conducted, and that individual submitted DNA and was also cleared of the sexual assault. And that the information that led to Mr. Talley having contact with law enforcement to begin with was Mr. Talley encouraging or attempting to force a young lady near or on the campus of LaGrange College, and that she's the one that called 911 when Mr. Talley left the scene, and later came back and said he was only joking and this kind of stuff, and kind of got him involved in this net where he became a suspect in multiple sexual assaults occurring in the jurisdiction, if I'm correct. Is that right? Close.
Close. The incident that brought him to the attention of the police actually occurred away from the college at a residence where I think he had been raking or doing some yard work, had heard that a woman was offering sex for money. He went to that residence, showed her the money. She kind of waved him away, and he took off, and that's what brought him to attention. But I would also like to make one correction. He didn't serve 26 years. He served 40 years.
Okay.
And there was an extraordinary motion that was brought jointly, I believe, by the Innocence Project and the district attorney's office that set aside the sentence and allowed him to be released. So with regard to the exoneration, you're correct. It was the one that was based on DNA. But to your point, Mr. Chair, Senator Robertson and I have been talking about this case for 2 years, and I want to thank you for, one of the concerns we had was just the logistical gymnastics you have to go through in order to get wrongful convictions addressed in a way that compensates those that, have suffered from that wrongful conviction. So thank you for that, sir. The issue that, concerns me as just real quickly background, I just retired, 50 years, 32 years as a police chief. This came to our attention in 2008 when the Innocence Project contacted us and said that they believed that Mr. Talley was innocent. We said, we'll work with you to get a buccal swab, send a detective down there. He got a buccal swab. That was 2008. There wasn't a finding for the DNA, which exonerated him from the only case where there was DNA available. That occurred in 2012, and that conviction was set aside. Based on the information that I had, I was concerned about the nature of the investigation. I signed a sergeant to reopen those cases. And it took him from 2004 until 2012 to 2017 to get enough information. And this is one of the issues, Mr. Chair, that you talked about, is evidence and how it's handled here. We had evidence at the PD, at the Sheriff's Office, at GBI, the court reporter, archives. There needs to be legislation that addresses where the evidence goes. It should be warehoused in a central location. Everybody and their dog had the evidence. And so as a result, evidence is lost, evidence is misplaced, evidence is destroyed, and as a consequence, the only physical evidence we had was for that one case. So that would be a recommendation that I would make, is that on any serious felony case, there be a central depository where all the evidence goes. It's not farmed out to, various folks that are involved in the case.
So when you're doing it, if I may, Chief.
Sure, yes,
So
sir.
when the active investigation is, you don't share with the Sheriff Department? It's not some kind of data center that houses all of this until the case is finalized or something?
It depends on the role. When you have a multi-jurisdictional investigation, the detective taking that evidence is going to follow the protocol for their agency. So if GBI is handling one aspect of the case and they get evidence, it goes to GBI. If the sheriff's off, in this case, we had an envelope that was found on one of the college students' windshield, and that was processed for prints. Mr. Talley's prints were not on that envelope. But it was turned over to the sheriff's office, so now they've got that evidence. And so to say that it's a bit chaotic in terms of how that evidence is handled would be an understatement, and would, I think, be a ripe opportunity for the state to come in and have central depositories, or give GBI the room in their evidence component to take all that evidence and hold it.
I don't know why, but I really thought we'd already did that. I really did. I thought,
Chief, are you talking at the conclusion of a
Yeah.
case?
Yes.
Okay, at the
As it's
conclusion, that's right.
As it's entered as exhibits in the court, and it becomes part of that court record.
Right.
When that case is over, it ought to go somewhere where it's all
for
together.
storage.
Along with the chain of custody of each piece of evidence that has been picked up along the way, so that can all be tied into a neat bow if we ever end up in one of these hearings like this, so that we could show how all the pieces came to this one
Yes,
conclusion.
sir. And more important
Right.
than that, as technology evolves and you want to analyze that evidence, you can get your hands on it.
so in this case, you're dealing with one case, and there were some other peripheral cases that may or may not have involved him?
Well,
or
he
is it
was-
just one that we're dealing with, and that's what they exonerated
It was
him
all of them. See, the working theory of the police chief at that time was this was a serial rapist. And when Mr. Talley was taken into custody, they put all those individual cases together, and those are the cases that he was ultimately convicted on. There was evidence that was not admitted, exculpatory evidence. For example, one of the witnesses was, and Senator Robertson will understand the significance of this, one of the witnesses blew or had a blood alcohol of over 0.3. And she made an identification based on voice. And her alcohol limit was, what, 4 times what the legal limit is to operate a vehicle? There was gloves that were identified belonging to that alternative suspect at the scene. Those were never recovered. There were a host of issues that, when the 2 sergeants got done investigating this from 2012 to 2021, they came to me and said, and these are not liberal individuals here. These are folks that have been doing this 15, 25 years. They came to me and said, I don't know how they pulled probable cause for a warrant, let alone convicted them. I think this was a case where heightened concern in the community, a serial rapist. There arguably may have been some racial components in it, but the fact is that it was a time where, when you look at the evidence, you're curious as to why these convictions occurred.
Can I ask one quick question?
Yes, sir.
Chief, did he plead any of these cases?
He had a one-day trial, and that included.
2 one-day trials.
Yeah.
Back to back.
Right.
Okay,
Yeah, he had a one-day
right.
trial, was convicted, refused to plead, had another one-day trial, jury trial, refused to plea, and then
Same jury.
after he was convicted back-to-back, he pled.
He pled to the last 3 charges. Was it 5 sexual assaults?
I think it was
There were a total of 6.
4.
6.
Yeah.
Oh,
There were a total
Yes,
of
go
6
ahead.
separate charges.
Okay.
So my name is Claire Gilbert. I am the former executive director of the Georgia Innocence Project. I was the executive director for 6
Could you
and a
speak
half
up,
years.
pull it a little closer to you so we
I was the executive director for 6.5 years and oversaw GIP's work in the latter years with the LaGrange Police Department on the Terry Talley case. And so he did end up serving 40 years and went to trial on 2 back-to-back one-day trials on very serious assaults, sexual assaults, was found guilty. They both drew from the same jury pool. He received 2 life sentences plus 10 years back-to-back each day, and then was encouraged by his attorney and his family, and he was completely distraught over the fact that he had been found guilty, though innocent, on these 2 cases, and ended up taking a plea on the remaining charges. On in the one of the two cases that he went to trial on is the only one where the Georgia Innocence Project or the LaGrange Police Department was able to find any physical evidence whatsoever. That evidence was tested and definitively proved Mr. Talley's innocence on that case. And then over the years, there was the reinvestigation that Chief Dekmar talked about, some by GIP, some by the police department, some cooperating with each other. That is where information came out about for example, the blood alcohol concentration of 0.34 in one of the cases that was never disclosed to the defense. The fact that witnesses had identified an alternate suspect was not disclosed to the defense. The fact that an alternate suspect had been developed, gloves matching that suspect's identified as that suspect's gloves was never disclosed to the defense. So there were a series of problems in these cases. Mr. Talley admitted to one of the crimes, and he had always admitted to one of them, and that was the first one that you discussed, Senator Robertson. That was what we refer to as the botched attempt to pay for sex. That case was never, the claimant in that case did not come forward until about 4 months after the incident had occurred. She did not call the police at the time that the incident occurred. And it was after all of this was in the news and she saw Mr. Talley again in the community that she came forward about it. Mr. Talley is not seeking compensation for that case or for another case that the DA chose not to exonerate him on. He was exonerated on 4 separate cases. One of those had DNA evidence of innocence, which enabled pulling the thread to show the severe flaws and lack of evidence in the other 4 cases. Those, all 4, were with agreement with the LaGrange Police Department, and we have a letter here that I will distribute that Chief Dekmar wrote in support of Mr. Talley on behalf of the LaGrange Police Department. Those 4 cases were exonerated. The DA chose to have 1, and then 2 were not. Those convictions were not vacated, and they remained on his record. However, Mr. Talley is not seeking any compensation for those cases or for the time that he served on those cases. Only the ones that he was exonerated on. And finally, I just want to add, in terms of the nature of a plea, that as executive director of the Georgia Innocence Project for years, I certainly learned about the fact that roughly 95 to 97% of cases resolve in pleas. People who are prone to influence and suggestion, like Mr. Talley, who the highest grade he graduated from was 6th grade in school, may be more subject to pressure to take pleas. And here, in this case, he fought hard. 2 separate cases, trial to trial, and they vacated those convictions. They convicted him despite the fact that he was innocent, and those were vacated as well. So I would also note that the fact that someone has pled guilty does not prohibit their convictions from being vacated or them from receiving compensation. 1 in 10 DNA exoneration cases involved a guilty plea across the nation. And just last year, Mr. Dennis Perry was exonerated by the legislature in the amount of $1.2 million for his wrongful conviction, despite that he had waived his right to appeal in order to avoid the death penalty.
Members of the committee, any comments, questions? Thank you very much. I appreciate your input and your comments. And
if I may say one very other brief thing related to your first questions, we are strong supporters of House Bill 364. We believe it's extremely important to have a reliable, predictable, objective process that these cases can go through.
Take the legislature out of it.
Correct.
Okay.
I have a quick question.
Yes, sir.
Ma'am, how's
Senator
the Georgia Innocence Project funded?
The Georgia Innocence Project is funded largely by donors, private foundations, thousands and thousands of individual donors. It's a 501c3 nonprofit. There were 2 federal grants to work with conviction integrity units, but that's generally the basis of the
Thank you, I
funding.
appreciate that.
And that brings up another point. It is so cumbersome when there's exculpatory evidence of somebody that's been in prison, and now you get evidence that maybe they're not guilty. And right now, it's a nonprofit that's carrying that banner, and there needs to be some mechanism. In fact, this case, I presented to the Georgia chiefs and also to the Commission on Accreditation for Law Enforcement Agencies. And as a result, they adopted standards for law enforcement that if there's post-conviction exculpatory evidence, then law enforcement has to have a process to handle that. We shouldn't be circling the wagons and creating obstacles to getting folks that ought not be in prison out of prison.
Well, Chief, to that, don't you, we're talking about a case that's there for 40 years. It's obvious that some of the rape kits were not sent to the GBI or missing. So in the perfect world, would we hold on to this evidence for 40 years somewhere?
And that gets to my recommendation of some
Right.
central, which means there needs to be some big warehouses. And I'm
Central,
thinking,
yeah.
Senator Robertson, that's a good point. I'm not even sure you have to maintain all that physical evidence. You take, swatches or samples of it and then preserve it. Because as you know, we've gotten DNA off of a small piece of clothing 20 years later. It's just a recognition that, there may be as technology advances.
But I think we're solving more cases now by people trying to figure out their genealogy than
That
anything
too.
else.
Yes,
Sadly so. But I do want to point out that the information, the testimony of the district attorney in the district does differ than, and I think you referenced it to the botched attempt to pay for sex, where Tally grabbed her by the arm and pushed her back inside the front door and tried to close the front door, and they got into a struggle and she got away from him, said the Asian female who identified Tally as the person who attempted to grab her. And so, there's always going to be those differences. So we need to make sure through the process, because it's a lot clearer when we have all of the evidence.
Right. Exactly.
And the thing with Mr. Tally, and that we have this one case where obviously he didn't do it. The suspect that they created obviously didn't do this either, if we're basing it, putting the same amount of weight on the DA in both of those cases. But then we have all these other cases, and some of those, like you said, where he is not seeking compensation on, but was convicted on. And so, all of that comes together and tries to give us the reason to do or not do what y'all are attempting. So that's
Yeah,
the
it's-
only thing I
In
have to
that
say.
one case, the botched attempt to pay for sex was initially charged as a misdemeanor, and then it got conflated with all of these other charges to a felony. And in the other case that he ended up also pleading on, and that we're not seeking compensation on, he has always maintained his innocence, and he still maintains his innocence on that one. That is just, he was given a choice whether he would accept exoneration and immediate freedom on the other 4 cases, or he could have stayed in and continued to fight.
Real weighty issues, we got to move on, but a comment from Senator C, please.
Yeah, I just want to thank you all for your service. I tell you, it's tough to listen to folk who are innocent and having to go through years of incarceration at the dime of, but it is hard to listen to that. And I'm just hoping at some point, and I've been listening to it for 20 years now, and it doesn't get any easier, and we've compensated several folk, but you can't buy back your life. You just can't do it. That's all, Mr. Chairman.
Right, thank you. Thank you for your comments, and like I said, we'll look at, next week, we'll have another hearing and another meeting at that time. Okay.
Thank you,
Hopefully deal
Mr.
with it.
Chairman,
Thank you.
members of the committee.
Representative Evans. We apologize, but these comments get pretty,
It's good to have a time limit.
yeah, it needs a whole new session, don't it?
You get a time
Thank you for your time and your patience.
No, thank you. Thank you, Mr. Chairman, members of the committee. And I have two, but they're related, and so if it's okay with the chairman, I'll just talk about
By all
them
means.
together.
Yes.
So
You're
House
gonna
Resol-
do- You're going to do it 364 first, or, I'm sorry, 48 and 49?
48 and 49.
Yes, go right ahead.
Yes, Mr. Chairman. House Resolution 48, which seeks to compensate Michael Stinchcomb, and House Resolution 49, which seeks to compensate Michael Woolfolk. They were co-defendants in the same case.
Co-defendants.
Yes, and they both served 18 years for a crime that they did not commit. They were the first individuals exonerated by the Fulton County Conviction Integrity Unit. They shot in self-defense. They had maintained that from the very beginning. At all times in this case, the physical evidence supported that they had acted in self-defense. The conviction happened really with the help of one eyewitness testimony who did not have great vantage point for what happened that day and had been inconsistent in their story several times, but nonetheless, it happened. The best eyewitness to see what happened was actually in the car with the person who ultimately was shot and is deceased, was sitting in the car with that person. That eyewitness was thought to be dead for a number of years. The prosecution found out that this person was not dead only a few years after the convictions happened, never brought that to the attention of the defendants or their counsel, but luckily those defendants were able to find that person on their own later, and that person's testimony, which was consistent with self-defense, is what ultimately led to the grant of the new trial and the ultimate null pros, which was the exoneration here. But very briefly, the gentlemen were in a house. There was a woman, the lady who died. She was shooting at these men in the house. They were ducking and trying to find cover within the home, but they were not able to do so because she was shooting through the window. So they grabbed a gun to shoot back in self-defense, and one of the bullets ultimately hit the driver of the car, or I think she was the passenger of the car, but that's how it happened. Self-defense from the beginning, backed up by eyewitness testimony that unfortunately it took too long to find. And these men, just like anybody who serves time in the prime of their life, missed out on their best earning years, missed seeing kids grow up, missed burying loved ones. And while we can't fully compensate them for what happened, we ask for compensation that's in line with what this General Assembly has done in years past. And appreciate your consideration.
Well, thank you. Any comments? Senator Robinson again?
Yes, sir. I'm sorry. Thank you. Now, you said, was she the driver or the passenger?
She was the passenger.
Okay, and so she was shooting at them in the house?
Yes.
Any reason as to why she was shooting at them that we know of?
I think they were in a fight. She was in a
so
fight with one of the men.
domestic type situation then?
Yes.
Okay. And the eyewitness that was later found, did that person give a statement at the time of the death?
No, they were thought, the driver, he was thought to be dead at the time that Mr. Stinchcomb and Mr. Woolfolk were going through their trial. He was only located years later. So he never testified in the original trial.
So he was never a witness, never spoke to police until he testified in the later trial?
Correct.
For the exoneration?
Well, yes, ultimately, they won their motion for a new trial from the Georgia Supreme Court after talking about the availability of this new witness. And then the Fulton County District Attorney's Office ultimately did a null pros, so they didn't move forward with the new trial because the evidence wasn't there.
So when did the prosecutor become aware of this witness?
We believe as early as 2009, which was only about 4 years after the
And who made them
conviction.
aware of this eyewitness? Was it the defendants?
No, he became known to the Fulton County District Attorney's Office because he was an eyewitness in other cases for them.
He's an expert eyewitness, is what we
Apparently.
like to call those folks, right, Chief?
Yes.
Yes, thank you.
Comments? Questions? Thank you very much, Madam
Thank you,
President.
Mr. Chairman,
Appreciate
members
your
of the
time.
committee.
Appreciate your patience.
Thank you.
Next, Representative Holcomb. Thank you for your patience, sir.
Thank you, Mr. Chairman, members of the committee. It's my pleasure to speak with you about House Bill 364. As just a little bit of background, I am a former prosecutor, and the first time that I was asked to work on one of these issues was last year. I worked on a resolution for Mr. Kerry Robinson, which Senator Beach then carried in the Senate. And to be candid with you, when I was first asked about it, I did not immediately jump at the chance to help. My own biases, I assumed that people that went to jail were in fact guilty, and I had to work through that. And one of the things that I've thought about a lot since becoming involved in this is there is no human institution on this planet that is perfect every single time. And our juries are a very good system. They work very hard, but they are not perfect, and they do not have a perfect record. So it is very important for us to have this possibility of compensation for individuals. And you've heard some of the harm already. I'll touch on it very briefly. Besides just their liberty being taken when it should not have been, one's health is greatly diminished if you spend time in prison. Everybody who spends time in prison, you have a shorter life expectancy than everybody else. They are not able to invest in their skills and in their careers, and often they are spending time in jail during the years when they should most be working. That means that they're not contributing to Social Security. That means that they're not contributing to Medicare. And so when they come out, they don't have access to the services that are available to everybody else who wasn't put in the same position. So what are we trying to do with House Bill 364? I'll give you an overview, and then I can go through any of the specifics. What it does is it effectively would end this process. I heard from many members in the House, and you all may feel the same now, that this is a really hard decision to make. And many legislators do not really feel like they have the background, the understanding, and the information to make these decisions. So what is proposed in House Bill 364, which is a bipartisan bill, and it might be helpful just to provide a little bit of context, this is not in any way, shape, or form a partisan bill. It was initially worked on by now leader Evstration. He started on it last year before he was promoted to become the majority leader. He worked on it, drafted it, and then asked me to carry it because he had a lot on his plate. And it was able to pass the House last year. There were some questions in the Senate, and to be fair, there were some issues that were unresolved at that time. But over the last year, we've worked to address some of those unresolved questions. And specifically what those were was the Supreme Court had weighed in last year informally and had said that they had a little bit of concerns in terms of the separation of powers issue. Those have all been resolved. And what we have done is we have set up the bill so that is an administrative function where if there is a recommendation for compensation, it would be a recommendation to the Chief Justice to then put it into the Judicial Council's budget. It is not the legislature directing what the judiciary does, and instead it is directing an administrative function of putting a line item in the budget. So what this bill would do is, as you've heard, the existing process requires an individual to file a claim against the state. That claim goes to the Claims Advisory Board, which is administratively attached to the Secretary of State. Those individuals don't have the expertise to really evaluate these claims either. You heard that there was one individual that they recommended have a compensation or have their compensation be approved. Generally what they do is they deny the claim. They may still say in their write-up and their recommendation that we believe the person is innocent and there's compelling information as to the person being innocent, but they generally deny the claim because the claim may be against the Department of Corrections, and the Department of Corrections didn't actually do anything wrong. They were provided with an inmate, they housed the inmate, cared for the inmate, and then they released the inmate. So we have this Claims Advisory Board, which is not really well suited to make these decisions. So what this would do is we'd keep the Claims Advisory Board, but then underneath it, in the meat of the bill starts on Section 4 on page 3, is this first, and this is really, really important, this only applies to the innocent. This is not for individuals that were released on a technicality. This is not for people that committed crimes and for whatever reason are being released. This is for people who are innocent. So that category of individual who did not commit the crime, but for whom their liberty was taken from them. So Part 4 on page 3 outlines that. This has been reviewed by the prosecutors to make sure that it's tight and that we're only covering innocents. And then we would set up a panel. The panel, and certainly if the Senate has different views on how to do this, we're all ears, but this is what we tried to do. You'll see on line 71, a judge, retired judge, or retired justice. The retired judge or retired justice, that was a recommendation from the Supreme Court to broaden the pool of individuals. As you all know, we have former Chief Justice Namias, we have former other members of the Supreme Court who could potentially serve in this capacity. They would serve on it. So we'd have that expertise of having a judicial officer who could make sure that this person is actually innocent. You would have a district attorney to represent the prosecutors. You would have a criminal defense attorney. And then, since most of the exonerations concern DNA, you'll see the appointments from the House of Representatives and the Senate would be individuals that have that expertise in forensics, so that way they could help, because that is usually the basis by which people are exonerated. The panel would be able to promulgate rules and regulations and develop forms, et cetera. The bill also carves out, one of the things that you've heard in the testimonies relating to the others is sometimes there are other crimes that take place that perhaps the individual did, but they are convicted of something that they didn't do. They cannot be compensated for those crimes, and there is a carve-out for compensation for them to satisfy the sentences related to those other crimes, if that is in fact what took place. And then the amounts for the bill is, this panel would review the evidence, make a recommendation, and then the amounts, which is on page 7, we did a survey of all the states, and my understanding is that 38 states have a process by which they have an independent board similar to this make these decisions instead of them coming through their General Assembly. So Georgia is a minority state right now as not having one of these processes. The average across the country is about 75,000. In real dollars, it may sound like a lot, but if you really take a step back and ask, would you take the deal of 10 years, 15 years, 20 years in prison for 75,000? Nobody on this planet would take that deal. But this puts within the board a range between 50 and 100,000, recognizing that the midpoint is that national average, but it provides some flexibility. So if the board believes that an individual should have a lower amount, and let's just say that that individual did not have much in terms of work experience, whereas perhaps somebody like me might be more towards the higher end of the scale if I was wrongfully convicted. So it gives a little bit of flexibility. There was debate about whether to set it as a flat fee or a set figure or a range, and what we settled on was a range, and those are some of the reasons for that. I will also, just in terms of context, it may be helpful to inform your decision-making. There are some states that are far more generous. There are some states that provide up to $200,000 a year. There are some states that provide health care for former inmates. And so this proposal is candidly fairly limited, but it at least has a good procedure set forth to make sure that, one, the individual is innocent, and then two, to give a recommendation. Then the last couple of things that it does substantively are, after this board, if it were to make a recommendation for compensation, is it would transmit to the Claims Advisory Board, because that will be administratively what it will be under, and then the Claims Advisory Board will transmit it to the Chief Justice with the recommendation that it be put into the budget. With that, the General Assembly will still have some oversight, so there is a safety valve. So let's just say that for whatever reason the board gets it wrong, before we appropriate that, they could alert us, and then we could make a change to the budget. I think that's highly improbable that that would happen. And so then this would just be placed into the public safety. I think how we do it in the different chambers is slightly different. In the House, we have a public safety subcommittee on appropriations. So it would come through that with the judicial council presenting it. And wherever the judicial council presents to the Senate would be where that would be presented. It would be line items for those specific individuals. And then that's the basic gist of it. And then the final thing, and this is on page 9 and 10, an individual can have a claim for wrongful conviction. So what this would do, and beginning on line 204 to the end of the bill, is it would provide a credit to the state. So if an individual has a claim for wrongful conviction, they don't effectively get to double dip, as the state will get a credit for that. And the second paragraph, subparagraph B, is that it's pending, and then there is a judgment. Any amounts awarded under this would just be applied to that wrongful conviction award. So we think that we've put together a pretty thorough piece of legislation to address this, but I'd be happy to answer any questions that you all have.
Yes, Representative Hogan, let me first, I really appreciate the effort in this bill, that's represented in this bill. I think it's really sorely needed. It really is. And we've complained over the years, at least I have, that we need to just take this out of our arena directly, so to speak, and do the thing that I think your bill is attempting to do. So I'm sure we all have some input on it, but I wish you well in it, and I certainly hope it gets some input from everybody so it can be pretty well structured and can stand the test of time. Representative Senator Beach.
Yeah, thank you, Mr. Chairman. Thank you, Representative Holcomb, for bringing this. We talked about this last year, creating something that's like this. So if this panel, this 5-member panel is created, they would be hearing these instead of us today, correct?
Exactly.
Number one.
Exactly.
Number two, if they decided this person should get $75,000 a year for 10 years of conviction, wrongfully being convicted, would that be paid in an annuity, or would it be $750,000 in cash?
As written right now.
It says cash, doesn't it?
It does say cash.
So, because right now we pay in an annuity, right? We give an upfront payment and then pay over annuity.
Exactly.
So that's, you would have to have some oversight from the appropriation standpoint if we have to, because right now we got 5.6 million just on these cases here. Now some of that's an annuity. I don't know how much is upfront payment. I'd have to add it up, but just wanted to ask you that, how the payments would be made. And I did see in cash online. I forget which line it was. I mean, which page it was, but
Senator Robertson validated that it
yeah,
has cash.
line 164, payment of compensation be made in the form of cash.
Correct.
So, I mean, do you think we should look at annuities or no, or do you think they should just get a check for whatever?
I do think that they should get a check, and the reason is the vast majority of cases that have come through the General Assembly, they're not people that spent 6 months or a year. They're people that spent 15 years, 20 years, 25 years, 30 years. They don't have cash. They don't have resources. What we hear about the challenges for when people are released from prison, how they get restarted, is they need housing. Housing is really expensive. This money, again, it sounds like a lot, but if you're working all year, you're paying a mortgage and then you're having a home that's worth something. So by giving these individuals money to make an investment in housing, to take care of their medical bills, which undoubtedly they are going to have. Your health 100% is less good when you come out of prison than before. And then, as stated, they don't have retirement. They don't have retirement because they've been locked up. And so to have cash, and what I will tell you is I had the concern initially of, well, being a little paternalistic, admittedly in terms of this view, of would they make good decisions?
No.
There are organizations that help these individuals to make good decisions when they're released. There's an organization called After Innocence. There's other organizations that work with these individuals, so they're not spending it in a way that's frivolous or wasteful. And I think they have an appreciation of time that's very different from almost everybody else because they lost so much of it. And I would like to think that they would be good stewards with the monies that they receive for that purpose. So my recommendation would be to keep it as cash. Certainly, if the Senate wanted to move in an annuity way, you certainly can. But I think cash better serves the purpose that we're trying to achieve.
Okay.
Senator
Thank you,
Rob-
Mr. Chairman.
Senator Robinson.
Yeah, thank you, Chairman Harbison. I want to be clear now, once the individual receives the money, does the state pay the attorney's fees out of the money, or is the individual required to pay the attorney fees out of the money that they receive? Because that's part of the legislation, that they receive the amount less attorney fees. Because I can only imagine, especially in some of these bigger cases, that's going to be a fairly good hit.
Correct. They would be paid the monies, and then the legal fees would have to be, effectively, they'd be reimbursing for the legal fees that had already been paid.
In putting the legislation together, I know Senator Beach was talking about it. Last year we looked at some of this, and we were looking at the possibility of hope for the individual when they got out to go to two-year tech school, or possibly even we discussed four-year college funding for some of these individuals and various things. But do you know of an avenue to where, and I'll use one of the judicial circuits that I represent, we'll say Chattahoochee Circuit, if an individual is convicted and it's determined that evidence was hidden by the prosecutor, other misconduct occurred, maybe I would never do it, thanks to Chief Deckmar being my instructor, but an officer that may have perjured themselves in court, and once this is discovered, is there any responsibility put back on the circuit that put this individual in the prison system to start with? Because like you said, it's not the Department of Corrections' fault that they received the individual and processed them in and took care of them. And I will push back a little bit on the health care, because the health care in prisons and jail have to be equal or better than the community standard. And I've written a lot of RFPs for health care for jails, and they have great dental care, psychiatric care, and medical care. But is the circuit responsible at all for their mismanagement or just wrongly causing an individual to be convicted?
I think there's different factors that could lead to a wrongful conviction. And what we're trying to do is to compensate the harm. The cause, I agree with you, is important. It could be that the jury just got it wrong. And one thing of note on that is, once you're convicted, in America, we're very lucky that you have the presumption of innocence before you're convicted. Afterwards, you don't. All the legal cards are stacked against you when you're convicted. So to get to a place of exoneration is extraordinarily, extraordinarily difficult.
Where did you find your definition of exonerated that's in the legislation? Was that Ledge Counsel?
Ledge Counsel, yes, and the prosecutors reviewed it for me too, because I wanted to make sure that it wasn't overbroad.
Yeah, because when I spoke to Ledge Counsel and we got hung up on the definition of exonerated, I did what any good student from Harris County would do, and I went to the dictionary, and it says free from guilt, and which I think is a very high standard. It means the individual is not guilty. And so we run into some of these, and I think you pointed it out, where we had a getaway driver who was involved in an armed car robbery where an individual was murdered. This person went to prison, stayed there for 20 years, got out on a technicality. There was never any doubt that he was and the prosecutor at that time said, you know what, this case is old, witnesses have died, this other thing, I just don't have the evidence to prosecute this individual. So under that circumstance, that individual would not qualify under your legislation, correct?
Correct.
Okay.
And what I would invite you to
Excuse me. No. Go ahead, Representative.
is that the district attorney would be invited to the panel, and that would be another safeguard. And I hear what you're saying, and I try not to do policymaking by anecdote, but sometimes it helps inform policymaking. I had a case that I prosecuted once that involved sexual assault, and it involved a very young victim, and it was pretty egregious misconduct. The young victim was very, very shy, did not want to testify to everything that had happened. And so in how we charged things, we were very careful taking that into account. Since the individual pled guilty, we got a conviction, but then, as you know, we have to deal with the sentencing. Since the victim did not want to talk about some of the humiliation that was inflicted upon her, the judge gave what I thought was a pretty lenient sentence. We had what's called bridging the gap session afterwards, where the judge met with the lawyers, and I was in the Army at the time. I was a JAG officer, and I'll admit I was beyond disrespectful. And I can't swear here. I tend to do that from time to time. But in my remarks, I said that you got it wrong, and he said, well, if I had known that A, B, and C had happened, I would have issued a different judgment. And I said, that did happen, I just couldn't put it in front of you. So that's different in terms of the court system, but there won't be those rules of evidence, and so a prosecutor could come in, could say, look, I tried this case, this person did it, don't award it, and I'm telling you. And I think it would be highly improbable that a panel would overrule a prosecutor coming and saying that. For all of the exonerees that the state has moved forward on, my understanding is that the prosecutors have not taken that stance. I have not done a survey of all of them, but I can tell you from the one that I worked on last year, that was certainly true. But I do think that we have a safeguard in there by providing that information or that opportunity for the DA to come and share his or her views with this panel.
Well, I think you've hit a lot of the marks in here, and I appreciate your work on this. And I do think it's important that we disconnect our heart from some of this stuff when we do write policy, because we can't put a face on it, because our intention is for it to impact 11 million Georgians should they find themselves in the circumstance. So I do appreciate your hard work on this.
Yeah. Senator Seether and Senator Beach, and let's be mindful of Beach. It's getting late, and I don't want to. My last question. Yeah, Senator C and Senator Beach.
No, I was just going to say I have an appointment. And I
Okay.
didn't want to leave without letting.
And it's really.
It is not my hair, thank you very much.
Senator Beach.
Mine looks all right, though, don't it?
You got one on too.
If it's over 1.5 million, the 1.5 million would be cash, and then the other 2.2, the other money would be in an annuity, because I tell you, if you got 25 years times 100,000, you're talking 2.5 million. Would you be, I know cash is important to get a house and to kind of get them back on their feet. Would you be amenable to a set amount of cash, not to exceed a certain amount, and then the remainder be paid in an annuity? And I think it would protect that person a little bit, because you're going to have family members and so on trying to come in and say, oh, you got $2.5 million, I need some money, you know, and you follow what I'm saying? And I think it might even protect them over the next 10 years if they had a 10-year annuity after they got the initial 1.5 million, for example, and limit it to no more than 1.5 million in the cash payment, and the rest would be paid out in some kind of annuity or payment plan.
Senator Beach, I think that sounds very reasonable. The only suggestion that I would have would be to make sure that the annuity would be inheritable by the individuals. So if the individual's life doesn't
Yeah, I think we've
match
done
up.
that before.
Right.
At least,
Correct.
With, one case I handled, I think we made it.
That's just something for the committee to consider.
And I think this is real good legislation, worthwhile of our attention. So if I could ask your consideration of it, do you want to move it up to the largest Senate? We're going to pass it up next week, and we'll look at it and try to perfect it with some of the amendments, so we could perfect it between some of the concerns that some of us have. We could just, and next week we'll move it out. Is that amenable to?
Yes.
Members will, if you come back, then we'll take care of it, okay?
Anytime, Mr. Chairman.
All right,
Thank you.
Thank you.
I know I got some other people, somebody else
Get
signed
your
that.
gavel? Where's your gavel?
No, they get my gat. Tiffany Bracewell, that was already
yes.
you?
I just wanted
Okay.
to sign in
And,
my
and,
name
and let me apologize, we
Tiffany
just
follows
really,
the rules.
it's some real serious stuff here, and we want to make sure we are very careful about how we craft it and pass it out. So please, if you come back next week, we'll give you more time, okay? Hopefully we can have it early in the day so we can have it. Thank you, members of the committee. If there are no other comments or questions, we stand adjourned.
Well, we
Thank
can do it
you.
at 7 p.m., can't we?
Even for the Army guy, we'll